Okay. Well, by my watch, it is 10 o'clock here. So I'm going to go ahead and get started. And, if folks trickle in, they trickle in. So good morning, everybody, and welcome to Township Tuesday, October 1, 2024. Now, today, I thought I'd talk a little bit about an interesting question that I got, a couple of weeks ago, related to our powers to sort of regulate signage in the roads. Now, before we get too far into it, I thought I'd share a little bit of news here. Um, so paid leave, that program is not actually going into effect yet, but the first requirements are starting to come due. First quarterly wage reports are due on October 31st. So the way you can report this is online through the unemployment insurance portal. If all of your, so this is coming from Deed itself, if all of your employees are covered by UI, no additional steps are needed. If they are not, you're going to have to start reporting wages. And they're hosting two webinars to help folks prepare. So if you just search Paid Leave Minnesota Deed, you're going to find these. If you want me to send you the link, just shoot me an email after the presentation this morning, and I'd be happy to do that. But they've got some webinars coming up. They also have some in-person ones coming up as well, and I'm happy to share those details with you if you are interested. Okay, so the question came up maybe 2-3 weeks ago. Township officer gave me a call and said, "Hey, look, we've got some concerns about sort of the proliferation of signage in our rights of way. We're worried about property values. We're worried about sightlines. We're worried about all that kind of stuff. We don't want to get into a situation where we are trying to regulate something that we don't have the power to, but at the same time, we also don't want to look like Hong Kong if we can help it. In terms of just having signs kind of all over the place. We like our rural kind of aesthetic, and we want to keep that." And this was sent me on a bit of a rabbit hole. So the first question, whenever something like this comes up and it's a bit of a new area, the first question that I always try to answer is, do we actually have the power to regulate this? Because of course, one of the odder bits about township government is that our powers are much more limited compared to other forms of government. Now, the answer is, turns out that likely we do, but that is a bit of, it's an argument by implication, which I don't super love in terms of the advice that I'm giving to folks. But basically, we have some powers that are sort of imply that this is a thing that we can do. One is our status as a road authority. All the other road authorities regulate signage in their rights of way. Implication being, as a co-equal road authority over our own township roads, we have the same powers with respect to them that the others do. Another is Minnesota Statute 160.27, Subdivision 1 and Subdivision 6, and 160.2715. Now, these ones talk about, we have the power to put up billboards with public notices. That's 160.27 Subdivision 1. And Subdivision 6 says we have the power to take down unauthorized advertisements. The fact that there is such a thing as unauthorized implies that there is such a thing as authorized. And likewise, 2715 makes it a misdemeanor for somebody to put up an advertisement without our permission. Nothing specifically really grants us the permission to grant or refuse it, though. And so one of the things that I am so going forward, I'm going to be recommending folks do is use the grant of authority from your electors. So there's this neat little power in 365.10 subdivision 17 that allows the electors to provide the town board with authority to do some specific things. So I think that's probably worth your time if this is a subject that you're interested in and you're trying to potentially regulate it. So the statute is here, sort of reproduced for you with our township official dodging a trap that I've been playing around a little bit with AI generated images, and I kind of like how this one turned out. Anyway, that's neither here nor there. So at the annual meeting or at a special meeting, you can ask the electors for a grant of authority to provide for a specific activity in categories like government and good order, protection of public and private property, so traffic safety in this case, benefit of trade, residents, trade, and commerce. So if you're worried about signage kind of taking over and potentially lowering property values, you could potentially use that as a hook. Promotion of health, safety, order, and convenience, and the general welfare. So we've got some sample language here, just in case folks are interested in doing this. So at your annual meeting, essentially the process would be you are asking for the electors to give you this authority. Now, for something like this, I would make sure that the authority that you're getting is in writing and it's relatively specific. So we would recommend that folks, come with something drafted for the electors to pass yes or no on, so you can keep it on file and so that you can refer back to it if somebody ever questions your authority to do this kind of stuff. But basically, we're sort of citing to our specific authorities here. We're making a little argument about signs can affect property values, signs can affect traffic safety, they can cause distracted drivers, and they can degrade the aesthetic environment. Everybody moves to a township because they like a rural environment, and signs can, by their nature, detract from that. So we're asking the electors for a finding that that's true, and we're asking them for a specific grant of authority to deal with that. So I think that if you want to regulate this, and you don't have to, but if you want to, this is probably worth your time at some point in the future. Okay. But of course, once we've decided to regulate, that's not the end of the question, because now we're into a particularly ticklish area. Now we've talked First Amendment a fair amount on this on this Township Tuesday before, so I won't go into it too much. But First Amendment incorporated against the states through the 14th Amendment, and we are creatures of the state. We are a political subdivision. We can't abridge the public freedom of speech. This has long been interpreted to mean that we can't restrict speech based on its content, and that can be a very ticklish distinction. So this is the kind of thing that you want to be very careful about. And we can multiply examples on this quite a lot. But I mean, here we've got some recent Supreme Court cases, relatively recent. I guess 1980 isn't that recent, is it? That sort of talk through what counts as a category as a content-based restriction and what does not count as a content-based restriction. And at least for me, this is not something that's very intuitive. So, for example, some of this stuff seems a little subtle. Like in Reed versus Town of Gilbert, we're dealing with restrictions that don't have anything to do with like the sort of message that the sign is conveying. It's not like they passed a resolution saying you can put up Republican signs but not Democratic signs, or you can put up Methodist signs but not Presbyterian signs, or anything like that. What they did is they put up different permitting requirements for stuff like political signs had one permitting requirement, ideological signs had a permitting requirement, temporary directional signs had a permitting requirement, and the mere fact that they were cutting these categories that closely, Supreme Court says, means that this is a content-based restriction. Now, content-based restriction doesn't necessarily mean that it can't survive, but it does put it on death row, if you want to put it that way. So what it does is it subjects it to strict scrutiny, which means that it needs to be narrowly tailored, so as narrowly tailored as possible to serve a compelling governmental interest. 99% of the time, if you get to that level of analysis, you are going to lose. Another one that's a little bit clearer to me is so Metro Media versus the City of San Diego. City of San Diego tried to put in a regime where you could put up commercial signs in a particular district, but you could not put up non-commercial signs. Not okay. Content-based. Some more obvious ones on the content neutral sign is if you are regulating based on the characteristics of the sign itself, not related to content. So if you are worried about, for example, distracted driving, you can say it can't be brighter than this. Or you can say digital signs can't flash faster than this, or something like that. You can't be above a certain size, for example. One of the ones that surprised me, particularly in light of Reed versus Town of Gilbert, is this one, City of Austin versus Reagan National Advertising of Austin, which said that you can, in fact, put up different regulations for signs depending on whether they were on premises or off premises. Meaning, I can have a lighter set of restrictions for a sign that is on my own property and a higher set of restrictions for a sign that is off my property. That's not content based. That they took the view that that's location based. But this stuff is very ticklish, and it's the kind of thing you want to be very careful about. So, just in terms of being helpful for folks who are trying to take a look at this problem and potentially making progress on it. We've sort of collected from around the states and from various other organizations best practices for ordinances going forward if you want to try to draft one of these things. And we will have some sample documents coming out. This one's ticklish enough that I didn't quite get them ready in time for this morning. We need a little bit more of a thorough review process because it's a bit of a new area for us. But things you want to avoid, for example, unfettered discretion. This is one that some of our sister organizations have mentioned that they've seen a fair number of their townships get in trouble for in the past. You cannot set up a regime where it's just case by case basis, chairman or the chair of the zoning commission or anything like that gets to say whether or not it's too distracting. Partially the issue is that it creates an appearance of unfairness. Partially the issue is that it has the practical effect of creating an accidental tendency to favor some speakers and some messages above others. But in any event, there's a lot of precedent saying that if you just grant total discretion to an employee or an elected official, you're going to get drop kicked by the court. Favoritism, kind of same thing. This is a way to accidentally make your regulations content based. For example, if you say that churches don't need permits, but every other sort of entity does, that's going to turn out to be content based, and it's going to get drop kicked. Another very normal way that we hear about townships getting in trouble around this kind of thing is flags. So if you say you don't need a permit for any sort of official flag, a lot of townships have apparently tried that one, but that turns out to be content based because you're supporting one set of messages and one set of messengers above another. So there's a fair amount of precedent that one is not permissible. But on the positive side, we have some things that do help, and we've got things like a statement of purpose. So what you are doing is laying down your marker. This ordinance is to be interpreted as content neutral. It's to be enforced as content neutral, and any provision to the contrary is to be read in light of this in light of this purpose. Severability. So the way that you reduce that one down to writing is something like we, the town board of such and such, would have passed each individual portion of this ordinance separately. The unenforceability of any one provision does not affect the enforceability of any others. And this sort of creates a line of defense in case a portion of the ordinance is found unconstitutional. It can save most of your ordinance if you end up getting in trouble for one detail or another detail. But the main thing that you want to make sure that you're including is, insofar as it is at all possible, you want to restrict based on effects rather than on content. That's sort of objective measures. So we were talking earlier about how forbidding signs that are above a certain level of brightness or interfere with sight lines for drivers. If it's a sign that's within 20 feet of a corner, you don't want to create a blind corner, or a sign that is interfering with the maintenance of the roadway. That's another one that you can potentially do. If you're concerned about the number of signs, you can forbid or limit the number of off-premises signs rather than setting a specific number as a way to sort of show that you're doing a location-based restriction, not a content-based restriction, which makes it much more likely to survive in court. Now, one other piece that's sort of interesting here is Minnesota law has an odd little provision on this, hiding out in Chapter 211B. It's 211B.045, and that says townships, all municipalities of which we're included, All non-commercial signs of any size may be posted in any number beginning 46 days before the state primary and the general election until 10 days following the state general election. Now, I'd advocate pretty strongly for including that in whatever ordinance you end up writing. And the reason for that is you don't want to create a situation where somebody is reading your ordinance and they don't understand that they have that particular right. Now, one way this can be a problem is if a citizen is reading it and thinks that it's forbidden when they in fact have the right to do it. I mean, obviously, we don't want to restrict people's political rights, so we want to be very careful about making sure that that average reader is going to understand that. Sort of a potentially more problematic situation from our perspective comes from the other reading, which is, you don't want to get into a situation where 10, 15 years down the line, somebody gets mad about a number of signs. You go check into your ordinance and you see, oh, well, we've got an ordinance that says no off-premises signs, or you're limited to one or two off-premises signs. This guy put up 15 campaign signs. It's got to come down. And then you try to do that enforcement action when, in fact, that enforcement is illegal. You can get yourself into an expensive court battle that you're going to lose just because the person who's trying to start this enforcement action didn't know to look in this particular portion of the statute book. So it is something that I recommend that folks do include in their ordinance. So, as I said, we've got a guidance document sort of cooking on this. And in particular, we're going to have some example clauses for most of those things. It's a bit of a process, sort of looking through all of these other township ordinances to try to collect best practices and pieces. But I'm hoping to get that one up by the end of the month here. So for folks who are interested in this topic, it is coming up. Okay, I think I saw a chat here. There's a sign in the residence yard. The school bus goes by every day that says F Biden. People have complained. Is there anything we can do about that? Probably not, unfortunately. This is one of those pieces that we probably deserved its own little topic. Thanks, Pat, for giving me the opportunity to pass on this. So there is such a thing as unprotected categories of speech: fighting words, obscenity, legal obscenity, which is different than normal obscenity. Yeah, speech that's integral to criminal conduct, fraud, libel, stuff like that. You can regulate that stuff in a content-based way because the First Amendment doesn't protect it. The idea, or the traditional interpretation, is that this stuff has such low social utility and has such a high probability for conflict and problems that we're just not going to extend the First Amendment's protection to it. That's traditionally how courts have analyzed this. But legal obscenity is a very high bar to clear. It's not enough just to say an obscene word, even in a place where it's not super appropriate, even in a place where kids can see it. There's a seminal case back from the 80s in which an individual was arrested for wearing a shirt that said "F the draft" in a courthouse. That one went all the way to the Supreme Court, and they ruled that he had the right to swear in public where kids could see it. So, it is what it is. It's been up for a long time, not just during election time. Yeah, our ability to limit that one. So that's speech about an individual candidate. It's very tasteless. Well, look, I'm not going to pass on the judgment. You don't need me to editorialize here. I understand communities often get upset about this, and as good, public servants, we often want to do stuff about things that the community wants to be upset about. If you're having this issue, and it would be helpful, I'd be happy to write a little blurb sort of explaining this. If you shoot me an email, I'll write you a blurb saying, hey, look, we probably can't enforce anything against this. So that you can blame me and not take it from and not take the heat from your citizens. We have a problem with signs being taken down or stolen. Political signs, particularly during election season, our power as a government is very limited in terms of how we can deal with this. This is the very highest core speech for the First Amendment. So it's very difficult for us to regulate it kind of in many ways. This is where the First Amendment is at its most protective. So the statute that I quoted for you is limiting. I mean, it's actually a step worse even than that, because on top of that sort of federal constitutional limit, we have this the state law limit that limits our power as a creature of state. So we have these two very serious limitations on our authority with respect to political signs, particularly during election season. That said, signs being taken down or stolen, that's just criminal conduct, right? Can't take somebody else's property. I put up a sign in my yard. I own that sign. That's a thing of value. Um, you know, even as a private individual, it is still criminal for me to take somebody else's property. Um, Now, how you deal with that, it's not great, right? The old prosecutor in me says if you're dealing with an area where this is happening regularly, one thing you can consider is putting up a trail cam, something like that. I would work with local law enforcement, see if they have one available. Put up two or three, just to get some good angles of the thing. Then put up the bait signs and wait for somebody to come back and steal them again, and then you can deal with it like any ordinary theft. That's kind of how I'd be inclined to handle the problem. But again, with that sort of thing, you're going to want buy-in from local law enforcement. You're going to want a little bit of equipment, and you're going to want to be ready to potentially. I mean, the landowner is going to have to be the one who pursues charges. Obviously, it's not really the township signs. The township's not really the party in interest, but you can potentially facilitate that if you've got a good relationship with your local law enforcement agency. Um, so yes, we cannot take them down. Private citizens also cannot take them down. Um, yeah, yeah. Are we responsible when the mowing contractor inadvertently shreds a political sign in the right of way? If this person is an independent contractor, most of the time they are going to be responsible for their own torts. Now, if you knew the guy was drunk when he got on his mower or whatever, we can end up in a different situation. But in general, if it's the whole point of an independent contractor is that he is liable for his own screw ups. That's kind of why you want to put that relationship together and why you're willing to pay a little bit more potentially in order to get somebody to do that stuff. So if you had that situation, I would tell the citizen like your beef is with the contractor. Sorry that that happened to you. Okay. Can you talk about the rule that we cannot lock the door at 8 p.m. on election night? Feeling safe. Well, uh, you may have played stump the attorney here. All right, let me see if I can lay my hands on that particular statute. Just a moment here. There are some very specific and potentially harsh limitations on poll hours and that kind of stuff. Uh, I can find this one in a quick fashion. I would be happy to. All right. Well, I'm not seeing that one with a quick search here. So, Nancy, was it? I'd be happy to shoot you an email after this. Um, and I can kind of give more detail if I can lay my hands on 8 p.m. Nobody else can come in to vote, but people are allowed to watch you count the ballots. That sounds right to me. That sounds right to me. Um, but I don't want to pass on it too much unless I have the statute in front of me because practicing law from memory is a bad idea, particularly in this context. If I give you wrong advice and you act on it, that's all of us can get in trouble. So let's not do that. The details on this are matter quite a lot. So Okay. Are there any other? Okay, folks. Are there any other questions here? Do we want to? We're feeling comfortable. I hope that was interesting, and I hope you guys got something out of it. Like I say, we'll have guidance document up on this with some sample clauses. It's already got kind of a sample resolution for your electors to pass. If this is something that you're interested in doing, you can just kind of take the thing to your annual meeting, and if you ask them to pass it, I think you are going to get that grant of authority, which can be pretty useful there. Um, and then that will ideally it'll have a sample ordinance as well, but we're going to see whether or not I feel like I can write something that is at both useful and at an appropriate level of generality for anybody in the state to take and modify. A lot of this stuff is kind of detail oriented, so you don't want to give people advice that works for Faribault County, but will screw you in St. Louis County, if you'll pardon my French. um, all right. Well, thank you all for your time and for your attention. Hope it was helpful, and have a nice morning.